This public hearing of the Parliamentary Joint Committee on Intelligence and Security for the review of the listing of Ansar Allah as a terrorist organisation under the Criminal Code. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, you are protected by parliamentary privilege unless you are giving evidence from outside Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. In accordance with the committee's resolutions of 7 September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. Finally, I note that the committee is seeking to conclude its report quickly, and members and witnesses are encouraged to provide all evidence in the room today rather than placing questions on notice. I now welcome representatives of the Attorney-General's Department, Department of Home Affairs and the Department of Foreign Affairs and Trade to give evidence at this classified hearing today. For the Hansard record, would you please state your names and the capacity in which you appear before the committee?
Zoe Moses, Director of Counter-Terrorism Policy at the Department of Foreign Affairs and Trade.
Richard Feeks, Ambassador for Counter-Terrorism, Department of Foreign Affairs and Trade.
Mark Ennis-Brown, First Assistant Secretary, Middle East and Africa Division, DFAT.
Gemma Smythe, Acting Deputy Secretary, National Security and Resilience Group, Department of Home Affairs.
Chloe Davidson, Acting Assistant Secretary, Security Law and Policy Branch at the Attorney-General's Department.
Catherine Murray, Acting Director, Counter-Terrorism Policy and Engagement Section, Attorney-General's Department.
Thank you all very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be reported by Hansard and attracts parliamentary privilege. I think we are ready to go. Do you have an opening statement? If you have one, please proceed, and then we could go to questions and or discussion as well.
Chair, I don't think any of us have a formal opening statement.
Great. I might kick off with a question that I have, particularly around the issue around Ansar Allah. One of the submissions that we have seen noted that Ansar Allah, there are many different names for Ansar Allah and appellations, if you like, and one of them, which is Al-Thawra al-Yamaniya, which means the Yemeni revolution, hadn't been listed in the AG. I think it was the AG submission or the Home Affairs Statement of Reasons, although you did list a number of known aliases. But this one seemed to be missing. Is that just an oversight? Because there are other names like the Thawra al-Yamaniya, there's the Resistance Front, the Axis of Resistance, and a couple of these kind of names that they're recognised as, particularly in their local media and in the media in the region. Yet they're not in. I noted they're not in the known aliases in the Statement of Reasons.
Chair, from my department's perspective, that would be a mere oversight, not a conscious decision not to list.
Right. Well, it might be useful to include those then if it's a question of what they call themselves and how they're named, and make sure that we're covering all the bases on that, I think. But yes, that was one of the names that's used quite a lot in media, in Arabic media circles. Can you give us now just going to the organisation itself, Ansar Allah, obviously there have been a number of actions they've taken particularly over the past 9 to 10 months since the Gaza war commenced, which have escalated over time, obviously. Does the sort of evidence also include activities that they've undertaken prior to the 7th of October last year and what their status was in that sense? Or is this a listing that other countries have moved towards and Australia is moving towards because particularly or specifically because of the actions they've taken, in the Red Sea, the drone attacks that they've conducted and other actions they've taken that can be described as terrorist activity, just particularly in the last period of time?
Chair, from the Department of Home Affairs' perspective, the escalation of the conflict was a significant point. The department, with colleagues across the table and other intelligence and operational organisations, continually review a number of groups internationally. But for the department specifically, it was the significant escalation in conflict from October last year. We routinely do consider historical actions of groups, but as I said, post 7 October, it warranted specific new consideration.
Well, that's interesting to me because prior to the 7th of October, it's not like they just appeared out of nowhere. I mean, there was an ongoing civil war in Yemen for a number of years. Some 150,000 civilians have died in direct attacks in that civil war, some 200,000 odd more from starvation and other malnutrition and other sort of humanitarian, like the humanitarian disaster was really quite stark. And Ansar Allah were very much involved in many of the attacks that occurred that killed civilians. I'm just curious, would the Australian departments, the agencies, consider that aspect of the evidence given the terrorist attack, or would they describe some of the attacks that they conducted as part of that civil conflict as terrorist attacks, or is it simply only done when they attack international shipping or cross borders and conduct transnational attacks?
Chair, can I just add to Ms Smyth's evidence that the statement of reasons sets out the basis on which the listing was made, and in that statement of reason it lists a series of attacks, and Ms Smyth's evidence is absolutely right that, post 7 of October there was clearly an intensification of those attacks. And a threat to global shipping, as you just mentioned, but the statement of reason also refers to attacks that preceded 7 of October. So yes, there was a sort of historical, trend, if you like, and very worrying, attacks from the Houthis over a number of months and years. But post 7 of October, those attacks intensified.
Well, I see on page 6 or 7 of the statement of reasons you do have a number of attacks listed in 2022 that were attacks against civilians and others and other kind of international shipping and cargo ships and so on. So there was a sort of pattern of this behaviour of these terrorist attacks prior to 7th of October. Obviously, it doesn't go deeper than that in the context of the attacks that were conducted against civilians within Yemen during the sort of intensity of that civil war. But nonetheless, I just was curious about that. The increase in the escalation in these attacks, when you're doing your statement of reasons to say, look, Australia should list Ansar Allah, is it based on an assessment of a pattern? Is it based on how many of these attacks? Is it simply the case that Australia might say we should list this group because they've conducted a small handful of terrorist attacks, but they are very much terrorist attacks in definition rather than other kinds of conflict-based violence? What's the reasoning behind assessing terrorist activity in that context?
So, Chair, we look at both legislative criteria under the Code as well as non-legislative factors in order to be able to determine whether or not, as departmental officials, we should provide advice to a minister. So the legislative criteria, and I can leave my AGD colleagues to go through it in more detail, sits under section 102(1)(2) of the Criminal Code. So that we look at whether or not the specific organisation is directly or indirectly engaged in preparing, planning or assisting or fostering a specific terrorist attack. We also look at whether or not they advocate the doing of a terrorist act. The non-legislative factors we also look at whether or not what the organisation's links to Australia actually are, threats to Australian interests, links to other terrorist organisations and groups, what like-minded countries are doing, listings by the United Nations as well. We look specifically at the organisation's ideology, their engagement in peace processes historically, implications for humanitarian assistance. So it's not that we have thresholds to clarify, Chair, on X number of attacks warrants us to take action. We look at all of the legislative and the non-legislative factors and we consider them at regular points in time. and make a decision as a collective as to whether or not we want to provide advice to government.
Right. I only have two more questions. One's on aid and exemptions and around that. There are, yes, I understand, existing exemptions when it comes to the usual exemptions when Australia or anyone else is providing humanitarian assistance to the very dire humanitarian condition of the Yemeni population. Those, I assume, would be the same exemptions as well for NGOs and others, because the fact is that they control part of Yemen.
So in terms of the legislation, there are some provisions that are enlivened by the listing of an organisation, and particularly looking at the associating with a terrorist organisation that do include a humanitarian carve-out. That's a very specific carve-out to that specific offence.
Yeah. As I said, they have a territorial control of a big chunk of Yemen, and the civil war goes on. My second question was about their relationship with other terrorist organisations, and specifically around their allegiance to the Iranian regime and the Guardian Council and Khamenei, and pledging allegiance to Khamenei. Are you aware of Abdel Malik al-Houthi's pledge of allegiance to the Supreme Leader, Ayatollah Khamenei?
Chair, yes, I've seen those reports. I think our general sense is, if it goes to the question of control and or direct influence, sort of directed by Iran, I think the general assessment is that it's not that there is a sort of degree of independence, but certainly those links. Practical, in terms of material and capability, have certainly seemed to have intensified over recent years, and so forth. We're also, looking at some other links that have been developing as well with other parties, but in this public.
But you'd be aware, Mr. Ennis-Brown, of the very clear relationship between. Not just in a sort of a symbolic sense, the Pledge of Allegiance, if you like, but the material material support provided by the Iranian regime and the IRGC to Ansar Allah, the training that goes on, whether there's operational control. I think that's a questionable point because there is a degree of autonomy, but there is a very strong relationship. And how does that play into the listing of the so-called Houthi movement?
Well, yeah, I agree. There are strong links. There's been weapons interdictions. This has been going on for some years, and it seems to have the extent of the Houthi attacks on shipping and the way they've been able to sustain that for many months now indicates that there's obviously some indigenous capacity, but there's been very strong Iranian support over a long period of time.
So I guess my question is, how does the government, and what is the precedent for this in the past, when a state effectively supports a proxy in these circumstances? One could describe that as a clear proxy relationship, and the level of support is both financial, semi-operational in the sense of capability, a provision of capability, and so on. When listing at the proxy, how does that then, how do we address the issue of, for example, the Iranian state being the sponsor of that proxy that's been listed?
I think all I could add is echoing the comments from Ms Smythe earlier, that what we're looking at for a listing decision is whether or not the statutory criteria is satisfied, and considering the range of non-legislative factors when we're making that decision.
I didn't understand that. So what does that mean? What does that mean in relation to Iran as a state which has these very clear linkages and direct relations? Again, material support, capability support, weapons, as you said, weapons interdiction has been part of the evidence, financial support, training support by the different elements of the Iranian regime, whether it be the IRGC or other like the Basagi group and whatever it might be. What happens when you list a proxy that has that kind of state sponsorship? What happens to our, in the context of the state itself that's doing the sponsoring?
Well, Chair, nothing really happens to the state sponsor because, as you know, the Criminal Code doesn't provide for the listing of a government entity. That's been discussed in various committees, but there are other measures we can take, and the government's, impose sanctions against Iran for a number of reasons, and the Foreign Minister announced a new package not that long ago. So we can take action separately, but not linked to Criminal Code prescription.
Right.
Because of the limitations of the Criminal Code.
Yep, understood. There are no arguments by anyone, I don't recall seeing any in the submissions, that would argue that Ansar Allah shouldn't be listed or the listing shouldn't proceed. Are you aware of any arguments that might say they're a legitimate rebel group seeking to oust the Sunni-backed government? No one's made that argument? No. As you're aware? No. Thank you. I might hand over to the Deputy Chair. He has any questions?
Thanks. Thanks very much, Chair. Just for completeness, Chair, unless Ms Mackenzie has any questions, I'll be asking the bulk of the questions today. Senator Patterson has provided me with some of the questions that I'll be asking today. He's on the line, as is Senator Birmingham.
Oh, right, okay.
Both of them have unreliable internet, I'm told. So, just to put you in the loop.
Thank you.
Now, can I just clarify? Perhaps this is a question for you to start off with, Chair. In your intro, you said that the hearing was classified.
Did I?
I'm not sure if that was a slip or not.
I don't think I said that.
But I just need to clarify. You did.
No, this is a public hearing, Deputy Chair. I said the hearing, okay. Just to clarify for you, I noted that the hearing is a legal proceeding of the Parliament and has the same standing as proceedings of the respective houses.
You also said it was classified. So I just want to make it clear that it is not a classified hearing.
I don't recall.
I'm not having a crack.
No, I'm looking at the script. At no point in this, at no point in my notes here did I mention that it was a classified hearing. So I'm not where you got that from.
All right, I got it from my ears, but be that as it may. Okay.
Okay. Well, I can assure you it's a public hearing.
Thank you. I was just, if it was classified, I was going to just...
Maybe you want it to be a classified hearing, Deputy Chair.
No, I'm quite happy for it to be public. That's all good. Okay, now my question now to the relevant witnesses. Thanks, Chair. Has in your explanatory statement, 5th paragraph, page 1, you talk about the Attorney General has taken into consideration unclassified information provided by the relevant agencies. To the AG's department, when the AG formed the view that he did he take into account any other classified information other than what's contained in the Statement of Reasons?
I don't know that I can add to the Statement of Reasons except to say that we obviously provide briefing material to the Attorney General to consider in deciding whether or not to, in informing his consideration as to whether or not he's satisfied that the criteria for a listing is met, and the decision is then based on the documents that you see before you.
I'm just... If I can refer you to the 5th paragraph of your explanatory statement, you specifically say that the Attorney General has taken into consideration unclassified information. Is it usual that the Attorney General is provided with both classified information and unclassified information when taking into account whether to make this decision or not?
I'm not sure I could comment on usual practice, sorry, but that statement there is a reflection of the material that I think gets prepared as the statement of reasons, which includes a statement in that document as to it being unclassified but corroborated where we've been able to do so.
So when you say you're not sure what the usual process is, why is that?
That's because I am only recently in this role, so I can't comment on what might have been the process previously.
Okay, and I'm sorry, am I talking to Ms Murray?
Ms Davidson.
Ms Davidson, okay. Ms Murray is there. Is she able to shed any light on it?
To that, I would say every listing, the Attorney General might seek additional information from agencies. I wouldn't say there's a particular standard process for each new listing as to whether classified information would be provided in addition to this usual statement of reasons.
But the point I'm trying to get to is, and I'm not asking you to disclose anything that's classified, obviously, is there anything that the Attorney General was provided that is not contained within his statement of reasons as to whether to exercise his discretion to list the organisation?
So the Attorney General would, in the ordinary course of things, be provided with a brief from the department with a recommendation, and that doesn't necessarily get captured in the statement of reasons.
Okay, so there could be additional information that has not been provided to us.
Yes, there could be.
And would that additional information, I would suggest it could possibly be classified, but does it mean that if it's not in the statement of reasons that's published that it is classified? I'm just trying to work out what information that we don't know has gone into the Attorney General's decision-making process.
I'm not sure I could assist the committee in terms of what information the Attorney General may know that's gone to his decision-making process, other than the role of the department in providing him with briefing.
No, I accept that, but is there additional information that the Attorney General's department has provided the Attorney General that's not contained within the statement of reasons?
I'm not sure I can add to my earlier answer about the brief that we would provide.
Righto. Now, if I can turn now to the time frame that this process has taken. The information that's contained in the statement of reasons we've heard evidence today about the long and enduring acts that have been undertaken by Ansar Allah or operatives therefrom. The first situation I saw where there was a listing of or sanctions being taken against a leader of Ansar Allah was against Abdul Malik Badr al-Din al-Houthi, which was on the 14th of April in 2015. Now, we heard earlier from, I think it was Mr. Innes Brown, or it could have been from Richard Feeks. I'm sorry, I'm not in the room, so it's a bit hard to tell, that one of the considerations is whether the UN provide certain sanctions against individuals. So that goes back to 2015, that the UN instituted sanctions against the current leader, Mr. al-Houthi. Perhaps Mr. Innes Brown, or whoever wants to speak on behalf of DFAT, can provide us with some insights as to why it has taken so long for this action to be taken when, there's been UN sanctions at least against the current leader going back to 2015.
Deputy Chair, You're right. There's been sanctions imposed on individuals in the Houthi organisation and the organisation itself for some time, and we've implemented those UNSC sanctions ourselves. The factors that Ms Smythe mentioned before being the approach that partners take, threats to Australian interests, links to Australian interests, they're used really to guide and prioritise consideration of whether to list an organisation or not. If it's listed, as Ms Smythe said, it needs to meet the legislative thresholds, and that's determined through a process of seeking AGS advice. And in this instance, the Attorney-General's Department sought the advice, and that advice showed that, that they met the thresholds, and the Attorney-General made his decision.
Are you Mr Innes-Brown?
No, I'm Mr Feeks.
Okay, sorry about that. I can't see your name tag
right.
from
no
here.
problems.
Mr Feeks, is it how often have you been involved personally in the listing of a terrorist organisation?
A good many times.
Good many times. Okay, great. So we know we're dealing with someone who knows what they're talking about.
Well,
excellent.
You decide that.
Yeah. Fair enough. Is it usual that that the government of the day approaches the Home Affairs Minister or the Attorney General, whoever has the responsibility of the Australian Federal Police at the time, depending on which government it might be? Is it usual for that person to approach the department? What I'm trying to work out is whether this is a politician-motivated listing or whether it's the government department that says, hey, we believe this has reached a certain threshold, government of the day, you should have a look at this.
Yeah. So,
what is the usual process?
So, I mean, Ms Smythe might want to jump in, but it's a consistent process which we've used over many years for the listing of many previous organisations, and that process is that any number of a handful of agencies, the agencies you would expect, national security agencies, AFP, DFAT, Attorney General's Department, can recommend a listing be made, and on the basis of that recommendation, across government there would be an effort made to bring together information that would support a listing. Once that information is brought together, that would be provided to the Australian government solicitor to determine whether the criminal code thresholds have been met. But it is, in practice, a process that is officials-led, if you like, and can be led by officials from a handful of departments, as I said. Okay,
so to distill your answer, the process by which ordinarily these listings begin is at a departmental level.
Yeah, that's the normal practice.
Yeah. Okay. And was that the practice in this instance in relation to the listing of Ansar Allah?
Yes, it was.
Okay, excellent. Thank you. Can you tell me why, going back to my earlier question, why it's taken so long for the departments to bring this to the government's attention when, according to your own material, according to your statement of reasons, page 2, it would be helpful if you guys numbered your pages, by the way, but that the Houthi movement adopted a slogan after the invasion of Iraq in 2003 to this phrase, God is great, death to America, death to Israel, a curse upon the Jews, victory to Islam. Why didn't that, back in 2003, start ringing alarm bells for any of the agencies?
Deputy Chair, I would say I'm not sure any of us can necessarily go to the specifics of discussions of officials in 2003. So I'm not sure we can comment on that. But we did, in this instance, obviously consider historical events. As I said earlier, all of us collectively consider regularly potential organisations, their activities, but whether or not they actually hit the legislative threshold in order to be able to list is a really important part of the process. There is, unfortunately, a lot of abhorrent activity by lots of groups around the world, but unfortunately sometimes does not hit the legislative threshold that we have to meet. In this instance, as Mr Feeks had said, we sought advice from the Australian Government Solicitor who confirmed that the criteria had been met.
So the statutory definition of a terrorist organisation is requires that an organisation directly or indirectly engages in, prepares, plans, assists in or fosters the doing of a terrorist act or in relation to a listed terrorist organisation, but the organisation advocates the doing of a terrorist act. Here's an organisation that back in 2003 had a slogan that it used as its catch cry, God is great, death to America, death to Israel, a curse upon the Jews, victory to Islam. Why wouldn't that have met the definition of terrorist organisation back in 2003?
Deputy Chair, I think there have been some amendments to those provisions since 2003, and particularly I believe it was 2023 that there were some amendments made to that advocating provision. So it wasn't necessarily the case that that was the law as applied in 2003.
So is it your evidence that prior to 2003 that Ansar Allah did not meet the definition of a terrorist organisation?
I couldn't comment on that. I'm merely saying we can't necessarily apply today's legislation to work out what the case might have been back in 2003 because there have been some changes to that legislation.
Okay. Well, what was the legislation back in 2003 then? What was the definition of a terrorist organisation back then?
I'd have to take that on notice.
Happy for you to do so. And when you do that, if you can provide some information to the committee as to depending upon whether it's the Attorney General's Department's view that the threshold wasn't met back then. I appreciate this is a slogan, but I would have thought that that would have, or at least should have, started ringing alarm bells back then. I mean, pretty significant slogan, I would have thought. Death to our closest political and defence ally, death to America, death to Israel, another ally, a curse upon the Jews, victory to Islam. I would have thought that that would have started to ring alarm bells, but all right, I'll move on. Do we know if the founder, Hussein Badr al-Din al-Houthi, is dead? I know there's a reference in, I think it's page 3 of your statement of reasons, that there's an announcement that he was killed, but that was back in 2004. Do we believe he's dead or not?
Deputy Chair, I think we believe he's dead. I mean, I've looked at the history and I think he was killed in an operation by the former, it was led by the former president of the Republic of Yemen, Ali Abdullah Saleh. I think my understanding is he was killed.
Now, one of the, I think it was Mr Feeks gave evidence earlier that apart from looking at the UN any sanctions the UN might have imposed upon the organisation or individuals in the organisation. You look at like-mindeds and how they deal with it. The US listed Ansar Allah as a terrorist organisation, did it not?
Yeah, they've listed, Deputy Chair, they've listed them as a specially designated terrorist organisation. I think they did that.
Specially designated global terrorist on the 19th of January 2021.
Yes, and more recently...
then they delisted later that same year.
So they were listed as a foreign terrorist organisation, FTO, and then they were delisted under that regime and relisted as a specially designated terrorist organisation, I think earlier this year.
So in 2021, they were listed as a specially designated global terrorist. Then that was revoked on the 12th of February. And then they were relisted again as a foreign terrorist organisation earlier in February of this year.
I think, Deputy Chair, it's the other way around. I think they were previously listed as a foreign terrorist organisation, FTO, and then delisted under that regime and relisted under the specially designated terrorist organisation regime recently this year.
And then that was revoked on the 12th of February 2020. Well, no, according to the top of page 4 of your statement of reasons, on the 19th of January 2021, the US State Department designated, that was al-Houthi as a specially designated global terrorist, as opposed to the organisation.
Yeah.
Yes, if you look at the bottom of page 6 of their statement of reasons, Deputy Chair, it has the United States listings for Ansar Allah.
I don't have page numbers on my document. Perhaps you do, but I don't.
It would be the second last page, Deputy Chair, of the statement of reasons, if that assists, under the heading listings by like-minded countries or the United Nations.
Okay. Oh no, that's links to Australia.
It would be a couple of headings under
by
that
like-minded countries. Yep, got that. Okay. So on the 17th of January, the United States announced it would designate Ansar Allah as a specially designated global terrorist group effective from the 16th of February 2024. So there was quite a lot of sort of shifting dynamics from as far as the US is concerned about first listed by the US 19 January 2021, but later delisted on the 16th of February and then relisted again 17th of January. Why all the back and forth, do you know?
I think, Deputy Chair, and I don't have all the details, but the two regimes operate quite differently, two US regimes, and the current regime, the specially designated terrorist group regime, allows for humanitarian and other organisations to engage in Yemen more directly. So it's a regime that has a bit more flexibility than the foreign terrorist organisation regime. And I think it would have been a decision within the US context around, which was preferable from the US perspective.
So when it was first listed in 2021, why didn't that, by the US, why didn't that start to ring alarm bells within one of the agencies in Australia?
Yeah, I can't answer that, Deputy Chair. I don't know.
Would you take that on notice, please?
Yeah, happy to take that on notice.
Thank you. The statement of reasons, are they ever updated, or is the statement of reasons that we receive as the committee and that they remain static as to what was provided?
They remain static, Deputy Chair.
By the Attorney?
Yeah.
Yeah, okay.
Unless any changes are made to the listing of the organisation.
Unless what?
Unless any further changes are made to a listing of an organisation. But for these purposes, they've remained static and have not changed since published.
Okay. I'm just mindful of going to the terrorist activity section on your statement of reasons, and then listing the directly or indirectly engaged in preparing, planning, assisting or in fostering doing of a terrorist act. There's a lot of information there about attacks by Ansar Allah on Red Sea shipping, and a lot of those attacks are listed as, sort of, without downplaying it, quite minor damage. But there's nothing in there, and I understand why, because this statement of reasons was provided prior to the sinking of the Ruby Mar. Is it worthwhile updating that, because that's a fairly significant change in the outcomes of what we've seen in the attacks in the Red Sea shipping?
What I would say, Deputy Chair, is I'm not sure of the benefit in the context of the use of the Statement of Reasons of updating it to document more recent activity. The Statement of Reasons is published at the time to support why the group has been listed. I can't see, unless other colleagues can see, a reason to update because of changes in activity. It doesn't change the status that this organisation is now listed as a terrorist organisation.
Okay. Good, thank you. Can I take you back to a question in relation to, I think it was Mr. Feeks was talking earlier about, with questions posed by the Chair in relation to the Criminal Code not being capable of dealing with government entities. But it seems to me that there's I'm not quibbling with the AGS's advice that the provisions of the Criminal Code may not necessarily provide for listing of government organisations. But what concerns me is that the Chair was talking about, Iran's involvement, and I think it was Mr. Feeks that talked about, well, the code doesn't enable Iran itself or the Iranian government to be listed, and that's the justification that the government has advised the Australian community as to why it hasn't sought or in fact listed the IRGC. But it seems to me like if you look at Hamas, for example, Hamas provides government services in Gaza just in the same way as, according to your statement of reasons, Ansar Allah provides government services in certain parts of Yemen. Can someone explain to me why that's different or somehow different?
Were you referring to Hamas then?
Mm-hmm.
Yeah, it was, yeah. And so we say that Hamas we know that Hamas is involved in running civil service in Gaza. We know that. The IRGC we've been told that the IRGC can't be listed because of its close involvement or close proximity to Iran. But Ansar Allah also provides government services in various parts of Yemen. So why is Ansar Allah able to be listed as a terrorist organisation when the IRGC, for example, is not?
Deputy Chair, you're right, of course, when you make the point about provision of services, and you use the example of Hamas, and Hezbollah is another such example, in terms of the provision of services, but also it's a terrorist organisation that has been listed. But the key here is the relationship to the state. And in the case of IRGC, it's part of the Iranian state. And in the case of Hezbollah, for example, it's not part of the Lebanese state. It's a political party which has, a number of other functions, but it's not part of the Lebanese state. And nor, of course, is Hamas part of a recognised state. And nor for that matter is Ansar Allah or the Houthis.
Because they're in a state of civil war with the Yemeni government.
That's correct. They're not.
Is that right?
The only country that has formally recognised the Houthi government and has allowed diplomatic representation is Iran. So the UN does not recognise the Houthis as the government of Yemen. Recognises the Presidential Leadership Council, which is presently headquartered in Aden. So the Houthis are not recognised as the government of Yemen.
Okay. All right. Can I take you to the part in the Statement of Reasons that talks about the process for the 2024 listing of Ansar Allah? Can I just suggest that in future you guys actually number your pages? That would be really helpful. So the last page of your Statement of Reasons, I think it is. So it's the numbered paragraph, or the page with numbered paragraphs 1 to 13. So 17th of January 2024, this process kicked off. So we can see that the process moved through quite quickly. 17th of January, as I said, then 23rd of January, Home Affairs provided the AGS with the Consolidated Statement of Reasons. 30th of January, AGS provided finalised legal advice to Home Affairs. The very next day, Home Affairs provided a submission to the Minister for Home Affairs seeking her consideration of the Statement of Reasons. But then it took 6 weeks for the Minister for Home Affairs to write to the Attorney General. So everything was moving along quite well until then. Why did it take 6 weeks for the Home Affairs Minister to write to the Attorney General, formally providing the Statement of Reasons and accompanying AGS advice and endorsing the proposed listing?
Deputy Chair, I can answer that one. As with any listing process, there's a significant consultation period across government and across officials leading up to the provision of the Statement of Reasons and the request for legal advice. The legal advice, as you can see, was obtained and provided to the Department of Home Affairs on the 30th of January. We then provided the submission to the Minister on the 31st. There continues a process of working through, particularly for respective departments, working through the legal advice to ensure for their respective ministers and others that the implications of the legal advice are known and understood. That period continues post 31 January, where we provide the submission to the Minister. The Minister and then other relevant ministers ensure that they are satisfied, and once that occurs, the Minister then wrote to the Attorney with her recommendation that the organisation should be listed.
So when did the Minister for Home Affairs, when was she provided with all of the requisite legal advice provided by all of the departments, as you say, to enable her to make a decision to then write to the Attorney General?
So specifically, we provided the Minister with the AGS legal advice. It was then up to other departments as to whether or not they had any implications as a result of that legal advice to inform their decisions. I'm not privy to any information.
AGS provided that advice. AGS provided that advice on the 30th of January.
Correct. So they provide their advice in relation to whether or not Sorry, Deputy Chair.
No, that's okay. There's a short delay, and I think we're sort of both talking over each other a little bit. The advice that you just spoke of was provided to Home Affairs. AGS provided finalised legal advice to Home Affairs on the 30th of January. But that's the advice that you spoke of. So what happened between the 30th of January and the 13th of March, and why isn't that documented in this process?
So to ensure, Deputy Chair, it's clear, the AGS advice pertains only to whether or not, their advice is whether or not the attorney should be satisfied that Ansar Allah meets the legislative threshold to be listed as a terrorist organisation. Post that, officials across the system need to ensure, as I spoke about before, there are legislative factors, non-legislative factors, and ensuring that government has the advice it needs in order to be able to, for the minister, the former minister, to be able to be satisfied to write to the attorney. I am not specifically privy to additional advice provided by anyone else aside from my department to my minister. Our advice was provided on the 31st of January.
So you don't, I'm not trying to put words in your mouth, and feel free to contest what I'm saying, but you don't know what advice was provided during the period of 31st of January 2024 and 13th of March 2024. You're surmising additional advice was provided.
I am surmising, Deputy Chair. I was not provided, the department wasn't provided additional advice that we then provided to the Minister, but as to what additional information the Minister was provided, I would suggest is a matter for the former Minister and for government, if there were discussions across Ministers' offices.
Sorry, once again, this is a bit difficult. You're Ms. Smythe, aren't you?
I am.
Yeah. So you are the Acting Deputy Secretary of National Security and Resilience Group. This is certainly in your bailiwick. Why wouldn't you have known what any additional material that would have come back to your then Minister for her to then make a decision to write to the Attorney General?
No additional, so to ensure you're clear, Deputy Chair, no additional advice came back to my department in order to be formally provided to the Minister for Home Affairs. So, okay,
so I'm confused then, because you said earlier as to the 6-week delay that 6-week delay could be explained because all this additional information would have been coming in from other departments to the Home Affairs Minister for her to make a decision as to whether she's then going to refer the matter to the Attorney General. But now you're saying you're not aware of any additional information that came to the Home Affairs Minister.
No, what I'm saying, Deputy Chair, is that other departments, off the back of receiving the legal advice from AGS, which was provided on the 30th of January, may have independently, outside of the Department of Home Affairs, considered the advice and the implications of the advice for their respective departmental responsibilities. I was not provided any additional advice that warranted me providing it to the Minister for Home Affairs. Outside of that, I'm not privy to what other departments may have either provided their respective ministers with or other ministers across government providing information or having discussions across government.
Yeah, no, I understand that you wouldn't know what's happening in other departments necessarily unless that departmental advice from other departments was being fed up to your minister. But no such information that you're aware of was provided by any other government department to your minister in that 6-week intervening period?
So I can't say conclusively no. If it was provided directly to my Minister Deputy Chair, I haven't been provided a copy of that information. I also, so I can take it on notice, but I also only commenced in the role at the very end of March this year.
Okay, well, we are talking about January 2024. Okay, so do you want to take that on notice then? Because it may be the case that there was some additional information that was fed in by other departments and you're just not aware of it.
I can take that on notice, Senator.
Your evidence was that there was a 6-week delay, and that 6-week delay could be explained by virtue of the fact that other departments could have been feeding information back into the Home Affairs Minister, but you're not aware of that actually happening.
Yes, in addition, also, Deputy Chair, not necessarily just information back into the Minister for Home Affairs. So I can take on notice any additional information formally provided to the Minister of Home Affairs, yes.
Deputy Chair, can I just make a quick comment? Not to the point about...
I can't see.
It's Mr Feeks.
Hello.
Yeah.
Thank you.
Not to the point about whether or not additional information was provided to the Minister for Home Affairs, but it's normal practice with a terrorist organisation listing, and it's not an insignificant step to take, that there's discussions, consultation that occurs between departments, between officials, as that terrorist organisation listing is taken forward. And that's been the case with previous listings as well. That may explain part of the 6 weeks, that there were ongoing discussions between departments about, the implication of a listing, that sort of thing.
Sorry, I'm just. I hope you can't hear all the noise in the background. Sorry, the joys of working from home. Okay, just similarly, just in relation to item 8 on that process for the listing, things after the Minister for Home Affairs wrote to the Attorney General. The Attorney General's department provided a submission to the Attorney General 6 days later, so things are moving along quite well. The next day, 20th of March, the Attorney General agreed to the listing, and then the Attorney General wrote to the Prime Minister on the 20th of March, and then it took 4 weeks for the Prime Minister then to write to the First Ministers of the states and territories. Can anyone there explain to me why it would have taken 4 weeks for the Prime Minister to have written that letter?
I'm not sure anyone at the table would be able to assist with that.
That would be a question for the Department of Prime Minister and Cabinet, Deputy Chair.
Okay.
Deputy Chair, we have reached 4 o'clock, which is at really the end of our allotted time, and I'll also remind you, you've had quite a long time for questioning, and this is a particularly, I know you're going down a path of questions around process, but we are, and then this is really a opportunity to examine the substance of the listing of Ansar Allah, or the Houthi movement particularly, and whether that should proceed on in our deliberations and our recommendations. So do you have any further questions on the substance of Ansar Allah?
Well, just on that point, Chair, it's absolutely to my point about the substance of whether the government acted appropriately or otherwise in relation to the listing of Ansar Allah when you look to the process of what it did when it went through that process. So I appreciate that. I appreciate your question, but it's absolutely goes to.
Well, I think you've had a very sufficient period of time to probe those issues through the line of questioning that you've conducted over the last half an hour. Do you have any further questions? Because we do need to wrap up.
Only to ask, is there anybody there that is able to take on notice or a question to the Prime Minister's office about the 4-week delay as to the reasons why it took 4 weeks for the Prime Minister's office or the Prime Minister to write to the Premiers and First Ministers of the other jurisdictions?
Deputy Chair, the only thing I could add is in terms of whether or not there was a delay. We obviously, as we're working through these processes, have timeframes in mind, and certainly from the Attorney General's Department's perspective in terms of the timeframes we need to meet for preparation of these documents, for making it regulations by the Governor-General, I'm not sure we would necessarily agree that there was a delay between the Attorney-General writing to the Prime Minister and then that ultimately being considered and approved by the Governor-General.
No, I've never suggested that there was a delay on the part of the Attorney-General. The Attorney-General has been prompt according to this material. The delays in... Yeah.
Just Deputy Chair, lastly, I think an important part of the process is once the Prime Minister writes to the state and territory ministers, he needs to allow time for responses from state and territory ministers as well. So I understand he wrote on the 18th of April and the state and territory responses were scattered across 3/4 of May.
Yeah, no, I appreciate that. Once again, my concern's not with the responses to the Prime Minister's letter. My concern is that it took a month from the time that the Attorney-General wrote to him to when the Prime Minister then wrote to seeking opinions or views from the states and territories. That's my concern.
Okay.
Perhaps, Chair, we could put on notice a question to the, and I would like to put a question on notice to the Prime Minister's office as to why it took a month.
Thank you, Deputy Chair, for your questions. I want to thank those witnesses that appeared. Thank you for your attendance today. You will be provided in due course with access to the transcript of your evidence and the opportunity to correct any transcription errors. If you have been asked, as you have, to provide additional information, including questions on notice, you will be contacted by the Secretariat to advise of the timeframes for those responses. And I now declare this hearing closed. Thank you very much for your time.